Thanks for joining us today for this special webinar on a major legal development that we know employers need to have on their radars as it impacts the enforceability of termination clauses in employment agreements, which creates risk and cost implications for organizations. For those of you that I haven't met, I'm Laura Williams, Managing Partner of Williams HR Law, LLP. Over the past approximate 15 years, we've been speaking about watching trends, anticipating court decisions, and updating and educating employers on the importance of ensuring your employment agreements and workplace policies are routinely reviewed. This is critical because, for reasons we'll review with you again today, termination clauses will be challenged by departing employees who want to increase their entitlements at the end of the employment relationship. But beyond just updating you on this important development, we also want to impress on you that in addition to updating agreements and ensuring that you do so properly, given the realities that we all know about how the post-pandemic workplace has changed the way we work, where leadership credibility is under scrutiny, culture's been shifted, and trust in management and HR is delicate. An organization's rollout strategy of new agreements for existing employees must be thoughtful, intentional, and strategic. So we'll also be providing some key takeaways and strategies on that front today as well. So in terms of agenda for today's webinar, Alex Pressey will kick us off by walking us through some of the key termination clause developments and trends, and we'll cover the major February 2024 court decision that prompted today's webinar. Then Joel Smith will walk us through strategic considerations that you need to keep in sharp focus when you roll out new agreements in your workplaces. We'll also have time for questions at the end. So please add your questions to the Q&A box as they occur to you as we discuss the content, and we'll get to as many as possible at the end. So without further ado, and to ensure that we're respectful of your time and we want to ensure that we can give you as much value as possible, I'm going to turn it over to you, Alex, to kick us off.
Thanks, Laura. And thank you to everyone who's joining us here today. So as Laura mentioned, I'm going to be chatting about the termination clause developments that have brought us here over the last few years, including the most recent one that prompted this webinar, and going through a couple of case studies to show you what this actually means in practice. But before I get into that, I'd just like to talk for a minute about termination entitlements and some of the foundational principles there. So when it comes to termination entitlements, the default, not to be confused with Dufault, the case that you are all waiting to hear about, is that employees in Ontario are entitled to common law, reasonable notice, and in other jurisdictions as well, or pay in lieu thereof. And this is an entitlement that's calculated based on a number of factors. You may have heard the term Bartle factors, which comes from a case from 1960. And essentially, it's a list of different considerations that judges take into account to determine how long it's going to take an employee to obtain comparable alternate employment. And those factors can include the employee's age, their length of service with the employer, the character or nature of the job that they're doing, and the general availability of similar employment in the economy at that time. So there's no absolute cap that exists with respect to common law reasonable notice, but generally it can go up to about 24 months, and there have to be exceptional circumstances for awards of more than 24 months or 2 years. On the lower end, it generally starts at a couple of months, 2-3 months, not generally lower than that. To sort of displace this entitlement, employers can do this with an enforceable termination clause in an employment agreement. And a termination clause that, again, is enforceable by being in line with legal requirements can limit entitlements to either statutory minimums, which in Ontario are set out in the Employment Standards Act 2000, or to some greater amount as agreed by the parties. So the ESA minimums in Ontario are a maximum of 8 weeks notice, approximately a week per year to a maximum of 8 weeks. And I say approximately because there's a little bit of wiggle room in the beginning. And for certain employers that have a payroll of over $2.5 million, they're known as severance employers. Employees who've been with the company for 5 years or more are also entitled to severance, which is a week per year, prorated for partial years, to a maximum of 26 additional weeks. So in total, if you're not a severance employer, the maximum is 8 weeks notice. If you have a payroll over $2.5 million, it could be 32 weeks or just under 7.5 months. And as I mentioned, parties can agree to something higher than the ESA minimums to gain predictability still, but not at those minimum amounts. And this is common in some industries, or say at senior levels in an organization, where you could agree to something as high as maybe a month per year of service or part thereof to a maximum of some number of months. That's again lower than those ultimate common law entitlements. So keeping all of that in mind, there are a couple of developments that I just want to help you recall over the last few years before we talk about the most recent one. And as Laura mentioned, the last decade and a half has been a time of change. The last 4 years or so have certainly been a time of change as well. I'm just going to be going back to developments as of 2020. And the first development that we're going to cover here was the one that determined that all termination provisions in an agreement must be considered together when assessing enforceability. And this happened in the spring of 2020, and this was a seismic shift. The case that decided this, Waxdale, which is mentioned there under the point. And again, all of these cases are ones that you can read about in more detail on our blog. This really impacted the vast majority of termination clauses in Ontario and resulted in an explosion of wrongful dismissal claims, as many termination provisions became void as a result of the decision. And essentially what this boils down to is where termination provisions, for example, deal with a for-cause termination, and that piece is unenforceable, as was the case in this case. So the with cause provision failed to meet the minimum requirements of the Employment Standards Act, because in Ontario, just because an employee has their employment terminated for cause doesn't actually mean that they're not entitled to their ESA minimums. They're only disentitled to their minimum notice if their misconduct meets an even higher threshold of willful misconduct, which is even more narrow. And in those cases, they're not going to be entitled to anything. So where a piece, a potential way a termination decision could roll out is unenforceable, the whole termination clause is found to be unenforceable. And this was a very, very big change, and the changes just continued. So in 2021, courts considered the relevance of sophistication of employees in determining the enforceability of termination provisions. And for a brief moment, there was a swing back towards interpretation of termination clauses in a way that could have been favorable to employers. And this was in a September 2021 decision called Rahman and Cannon Design, where the court held that if a party demonstrated themselves to be knowledgeable and actively involved in the negotiation of the termination clause, or the agreement generally, the termination provision should still be enforced even if the clause technically failed to comply with the ESA. And many, were excited because they viewed this as a potential defense to respond to the 2020 development that I just mentioned and save an otherwise void termination clause. But just to demonstrate how quickly the law can shift, starting a month later, another decision came out in a trend that was subsequently followed, where courts declined to apply this reasoning and held that an employee's sophistication or the receipt of legal advice doesn't save an otherwise unenforceable termination clause. And even the case that had opened that possibility of argument, the Rahman decision that's again noted here, was overturned on appeal in 2020. And the changes continued from there. So in 2021, A further principle was something that employers had to contend with, which is that substantial changes to employee roles or duties can render the termination clause unenforceable as well. And this doesn't mean, a small change, but the circumstance here that the court was dealing with in coming to this decision was one where an employee's responsibility changed in such material ways over 12 years since the employment contract had been signed that even though the formal title was unchanged, he became responsible for a huge swath of duties that he hadn't previously had to do. And so in this case, the court refused to enforce the termination clause because they essentially said that the substratum of the agreement had changed. So the material terms of the written employment contract were changed so significantly by being eroded piece by piece as the employee's responsibilities expanded, that the court said, well, this termination clause and the contract generally could not have been intended to apply to the role and circumstance that the employee ultimately occupied. So again, employers had to contend with, well, had there been significant changes in an employee's role, had employees had their employment agreements updated over the course of their time with an employer. Because without an enforceable termination clause to rely on, the employee again would be entitled to reasonable notice under the common law. And the last of these changes that I want to bring to your attention was in 2022, when it was found that unenforceable termination language anywhere within the employment contract can invalidate the termination clause. So this is really an expansion and a continuation of the trend that started in 2020 when we said, an enforceable part of the termination clause with respect to, say, with cause termination can invalidate the rest of the termination clause, including in without cause, different circumstances. In this case, the termination clause was actually enforceable in isolation, but there were other clauses, confidentiality related, conflict of interest related, which could have led to termination without notice. And so essentially these other clauses said that in certain circumstances, an employee's employment could be terminated. They were ambiguous, they didn't really set out the entitlements, and they arguably could have violated the ESA. And as a result, the court found that, as I mentioned, unenforceable termination clause anywhere in the employment contract, not just as part of the termination provision specifically, could invalidate the termination clause. And all of those developments bring us to the current development in the Dufault and Corporation of the Township of Ignace decision. So in reaching this decision, the court actually relied on many of the principles from the cases we just discussed because the termination clause was challenged on many grounds. The termination clause in this instance provided that the township may terminate the employee's employment at its sole discretion and without cause at any time. And the plaintiff brought forward a number of arguments. As I said, they were in line with the recent developments that I just covered. So I'm just going to be focusing on the novel argument that they brought forward, and that's the one that's sort of driving the impact of this decision. And so the challenge was to that ability by the employer to terminate employment in its sole discretion and without cause at any time. The court found that the clause contravened the Employment Standards Act when it gave the employer that sole discretion because the court accepted the plaintiff's argument that essentially there are times at which the Employment Standards Act prohibits the employer from terminating an employee. Say on the conclusion of a job-protected leave when an employee is entitled to reinstatement, or in reprisal or retaliation for an employee exercising their right under the ESA. So essentially, while an employer can terminate on a without cause basis at any time, it's at any time that isn't in violation of statute, isn't discriminatory. Again, there could be some additional pieces there, but essentially it's not an absolute right, and the employer's right to terminate the employee's employment is limited in certain circumstances. Because this was actually a fixed term employment agreement, the court in this case found that the plaintiff was entitled to the balance of the contract, which was 101 weeks pay. But it's really important to note that this applies to Ontario termination clauses in all contexts. So it's not just fixed-term employment agreements, but indefinite employment agreements as well. Termination clauses and all sorts of employment agreements would be vulnerable to challenge based on this development. And so as a result, I think it's helpful to consider practically, what does it mean when the termination clauses aren't enforceable? I talked generally about common law reasonable notice. We covered all of these vulnerabilities over the last few years. So let's take a quick look at some case studies. So what I'm going to ask you to consider, and I'll just pause for a couple of seconds after each example, is how much notice would these employees be entitled to, both if they had an enforceable termination clause in their employment agreements and if they did not. And so the first employee example that I'm going to give you is an employee who's 63 years old, has 38.5 years service, is a professional engineer, and designs software unique to the employer in Ontario. And so just take a couple of seconds and consider, with this 38.5 years service, what would they be entitled to under the ESA? And then what might they be entitled to at common law? And I won't keep you in suspense for long. An employee in these types of circumstances would be entitled to the maximum amount of notice under the Employment Standards Act, so 8 weeks. If this was a severance employer as well, the employee could be entitled to another 26 weeks, so a total of 34 or just under 7.5 months. However, in the case that this example came from, the employee's termination clause was successfully challenged and the employee actually was awarded with 30 months notice because of the length of service, the specialized role, and the lack of comparable employment at the time. So again, an enforceable termination clause makes a very big difference because 8 weeks, much less than 30 months, and even where the employee is entitled to severance, 7.5 months, much less than 30 months. In our second example, the employee is 50 years old, has less than 5 months of service, so very short service, and is a senior project manager. And so in this circumstance, even though generally a shorter period of service lends to a shorter notice entitlement, if this employee had an enforceable termination clause, they'd be entitled to 1 week's notice. However, because there was no enforceable termination clause, in this case, the court actually awarded 5 months and 2 weeks due to the specific nature of the role and also the short term of the employment, which would have required the employee to explain to prospective employers why his employment was terminated so soon after hire, as that would negatively impact his ability to find a job. So his notice entitlement ended up actually being higher than the amount of time he had even worked for the company. And the final example here that I'd like to present for your consideration is an employee who's 56 years old, has 13 years of service, is a controller or chartered accountant, and had their employment terminated during an economic downturn in the oil and gas industry in Alberta. And the reason that I think this is an interesting example as well is, while the cases we were talking about are Ontario cases and courts in Alberta don't have to follow Ontario case law, it can still be persuasive. And again, even though there's no severance pay entitlement in Alberta, the notice entitlements under their employment standards legislation are quite similar. So in this case, with an enforceable termination clause, the employee would have been entitled to 8 weeks notice. If similar circumstances occurred in Ontario and this was a severance employer, there would have been 13 more weeks of severance, so a total of 21 weeks. But either way, much less than the 18 months that the employee was ultimately found to be entitled to. So with those sort of practical applications of what this means in mind, I'll turn it over to Joel to discuss the takeaways and strategies.
Thank you, Alex, and good afternoon, everyone. As Alex said, now you know what the development is. You understand the decision. What's next? What do you do now? And before I dive right into what do you do now as an employer, I want to acknowledge something. I recognize, I'm sure many of you are feeling, this is frustrating. The law keeps on shifting. The enforceability of our clauses keeps on changing. What's the point? Why do we keep on doing this? And the biggest point I want you to keep in mind as you're considering that is that termination clauses are still extremely valuable, and they very, very frequently provide huge benefit to employers, especially when you are on top of these developments and update your employment agreements regularly when these big developments occur. You're all doing the right first step. You're all here spending your day with us, but I'm sure you have many other things to do to make sure that you know about the developments. And so you're already ahead of the curve. So what do we do? Why does this matter? In our practice, we frequently assist our clients with responding to demand letters from employees and their lawyers. This is bread and butter work for us. We get a demand letter, an employee has been let go. The employee or their lawyer is claiming that they were let go, it was unfair, and they're entitled to exponentially more than they received or were offered at termination. In those circumstances, if there's a solid termination clause in place, which typically is the case for those clients of ours who are regularly reaching out to us and ensuring that their agreements are up to date and enforceable. In those cases, we can take a very strong stance to just simply refuse to negotiate. And that's a position that we'll often take. If the termination clause is updated, if it's enforceable, you can really dare that former employee to sue. And the reality is, in most of those cases, when you take that position and the termination clause truly is solid, they're not going to take you up on that dare. They're not going to sue, and they will abandon their claims. That differs greatly when you're talking about a termination clause that's outdated. Alex spoke about it before. There's so many different reasons why a termination clause can be impacted, and the reality is, employee side lawyers know that. They understand the huge benefits of taking a run at these clauses, and they will do so where there's room to do so. And so if the termination clause is susceptible to challenge, then litigation is very likely, and additional costs is very likely. And so, the way you avoid those additional costs is, ensuring that you have your clauses up to date and you're implementing new agreements, including for your existing staff, when these big changes occur that may impact the enforceability of your clauses. So it's right there at the top of your screen. Is it worth it? Is it really worth it to go ahead and take these steps? Well, some of the really important benefits, I've spoken about them just a moment ago, but let's go into a little bit more detail. First of all, you can minimize those termination costs. Alex spoke about this as well, and so I'm sure many of you are already pretty familiar with some of the concepts. We're really not exaggerating when we say that it's very common for an enforceable termination clause to change an employee's entitlements from being years, 2.5 years at the high end of compensation, and instead it being up to 8 weeks or up to 34 weeks for larger employers. The swing is huge, and in other provinces, generally it will cap out at that 8 weeks. And so there really is a big swing in what those entitlements can be. The benefit of those costs is it's right there. That yes, it's time for you to spend updating your agreements. There's work to be put in. There's some cost there. That cost is outweighed dramatically by the benefits that you'll receive if you take these steps and ensure that you're staying up to date. So the next point, greater flexibility, greater predictability. I'd like to just make a note here. When I'm talking about greater flexibility, greater predictability, I am talking about the ability to dismiss employees. Now, terminations should never be taken lightly, of course. And those of you who know our firm, well that we take these things seriously. These are major decisions for the employer. These are major decisions for the employee. For the employee and their ability to make a living. For the employer and the costs of bringing on new staff, of changing the way that work is done, culture, all of these different things. But that doesn't mean that there aren't opportunities where a termination makes sense. There simply are in many cases, and employers need to be ready when those opportunities present themselves to take these steps. And if you have an enforceable termination clause, it's predictable. Generally what that cost is going to look like, and you can be flexible. You can take those steps when you need to take those steps if you have that termination clause. If you don't have the enforceable termination clause, we hear this from clients regularly. The much greater cost that they might be facing can result in them not taking a step that's right for their organization, that's right for their business. And you simply shouldn't let these These opportunities fall by the wayside just because you didn't take the, relatively straightforward, not completely simple. That's why you're here to hearing from us, but relatively straightforward steps to put some of those changes in place and ensure that you're ready to predictably make the changes you need. And these changes and the benefits of this are as important as ever right now. Of course, we have a weaker economy right now. That's the reality. I don't know if technically we're in the recession now, but certainly the economists have been talking about that being a possibility very, very soon. We may be there now, and so with that comes more terminations. It's something that we're seeing in our practice. It's something that you see in the news. There are layoffs, there is downsizing, and I'm sure that you're experiencing that in your own organizations as well, or at least considering it. And so, with those possibilities, terminations are more likely. And if you're going to have to look at terminations for cost-saving reasons, well, it's best to be able to know what those costs are and allow the cost savings to be, as much as possible where you need to make these changes. In addition to that, it's been a tough go for employers these last few years. The pandemic job market was off the charts. It was hot as it's been in decades. What that meant was it was hard to find good talent. It was hard to retain good talent. One of the outcomes of that was employers making hires that they may have regretted down the road. They hired someone because they needed someone in the role, and it turned out not to be the right person, and they couldn't find that right person at the time. Well, employers are still, facing the consequences of that, still considering how to take those next steps and get the right people into the roles. And as the job market has softened quite a bit, now and in the near future are times that you can really consider that. And if you have enforceable termination clauses that a predictable, reasonable cost to take that step, let that wrong hire go and bring on the right person when that person might be more available in the marketplace, that's the time to do it. But it's a lot harder to make that decision if you don't have that enforceable termination clause. So let's move forward to the next slide. And I really want to leave you with the understanding that this is an opportunity. This is an opportunity for you as an employer or a representative of an employer to level up. It's not just about agreements, it's agreements and policies. And I'm going to tell you more about why that's the case. But certainly, first of all, you want to revise your employment agreements now, or certainly have them reviewed. This change is impacting many employers across the province. Many of you here, even if you've recently had your employment agreements updated, you may well be impacted, and you should be seeking advice to determine whether you are impacted by this change. If you are impacted, you should get those employment agreements updated. That's not only for new employees when you're putting your templates updated so that when you bring on new employees, they have an up-to-date contract. It's for your existing employees as well, so you can reap all the benefits that I just spoke about of making necessary business changes where it's appropriate to do so. Now, there are also many policies that could impact the enforceability of termination clauses. So it's not just about the agreements. And Alex touched on this a little bit. The Waxdale decision that she spoke about from 2020 and some of the decisions that follow it, as Alex was saying, they really suggest the principle that no matter where in the employment agreement the language may be, if it refers to termination and it potentially doesn't comply with the minimum requirements of the Employment Standards Act as that relates to termination, all of the termination clauses or termination related clauses in the agreement can be unenforceable. So it's not just about the termination without cause clause. It could be any number of other clauses. There's another step that the law may shift to when you consider that. Many employment agreements will import policies by reference. So they'll say that the employee agrees to comply with the organization's policies. That is best practice. That's something you should absolutely do. But the risk becomes, if those policies state something about termination that would not comply with the Employment Standards Act's termination requirements, there's a risk that could actually invalidate the termination clause in your contract. Now, we haven't seen that yet in the case law, but that doesn't mean that we won't. We've talked about how employee side lawyers are constantly taking runs at clauses that might be subject to challenge. And this is something that those lawyers have on radar. You could trust us on that. We know those lawyers. We see the demand letters. We know what they have in mind. These are arguments that are being put forward, and it may well just simply be a matter of time before the courts start looking at the policies as well to consider enforceability of termination clauses. And these policies are more common than you might realize. An example of the kind of policy language that I'm talking about could be a policy that sets out some sort of expectations for employees, confidentiality, code of conduct, whatever the case may be. And it may have a little sentence somewhere near the end of the policy that says something to the effect of, if you don't comply with this policy, you'll be dismissed without notice or pay in lieu of notice. That type of language, was much more common years ago, and it may still be lingering in your policies and in your employee handbook. That type of language is, some of what I'm referring to, a pretty common example of what I'm referring to that could create concerns for the enforceability of your contract now as well. And so, as you're looking at updating your agreements, you really should turn your mind to updating your policies as well. It hasn't been a great time for a lot of employers to update your policies these past few years. HR professionals, business owners, managers, you've had a lot to contend with these last few years. The pandemic wasn't easy to manage. Where we are now, you should have a little bit more of an opportunity to catch your breath. Depends on your organization, I recognize. But it's more of an opportunity to look back and really make some of these changes that maybe have been necessary or important to be made for the last few years. Now, when we're talking about updating policies, the enforceability of the termination language is only one of the changes that you should consider. There are other compliance related issues that you should consider in updating your policies as well. Rules have been shifting dramatically during the pandemic. Of course, many of you will know, for provincially regulated Ontario employers, there's some new policies that you need the last couple of years: electronic monitoring policies, disconnecting from work policies, what have you. So there are a number of new ones that you need to implement if you haven't done that. That's certainly not it. In addition to that, some other changes in the law and the case law and legislative obligations may change the language that should be set out in your policies as well. So there was a recent development. If you read our year in review newsletter or read our webinar, you would have heard about this. There's a change in reporting deadlines for the WSIB. Many employers have policies that set out, by which date you'll be reporting to the WSIB. Those may now be outdated. There are some health and safety requirements changes for certain industries over the last couple of years you need to be mindful of. There are many developments in the case law that impact policies, developments in how the courts and tribunals interpret accommodation requirements for employers that might impact your accommodation policy. Changes in the way that the courts and tribunals are looking at workplace investigation obligations. Those might impact your investigation-specific policies, your harassment policies, your violence policies, and the list goes on. There are so many different changes in the law that really should be captured by your policies, and you should be updating these things every couple of years with legal advice as you do so, to ensure that you are taking into account those changes in the law. Now, the other thing you want to consider when we're talking about updating your policies, the way we work has changed. I've said this a number of times over these last few years, and so if you regularly attend our presentations, our webinars, you may have heard me say this, I will admit. But the way we work has changed, and that does need to be reflected in the policies that guide, the way that your employees are supposed to work. Hybrid work is an obvious one for many employers that, shifted to a more hybrid approach or a remote approach that didn't exist before the pandemic. But there are so many other changes that have occurred in the way that work is performed these days that need to be considered by employers as you update your policies, because your policies are there to create expectations, clarify expectations, ensure your employees understand what you need of them and what you're going to do for them. And if your policies are outdated and don't reflect the way that you work, they really aren't doing the job. So with that, again, the call to action here really is: look at your agreements, look at your policies, look at introducing new agreements and policies, now when you have a great opportunity to do so. Now, if you're going to do that, you need to be careful while you do so. Make sure that you are considering the strategies that are necessary to do this right. Make sure you're considering the legal obligations that are necessary to do this right. So some of you may know, and I won't spend a lot of time here, but some of you may understand, when you introduce a new employment contract for your existing employees, it's a little more complicated than when you do for a new employee. A new employee, you give them your contract, you give them your policies, you ask them to review, sign off, and sign off in order to accept the job before they start the new job. If they do all of that, they aren't working for you until after they've signed those agreements, those policies, you're set. You can rely on those agreements and policies, of course, subject to changes in the law and the language in there. With your existing employees, it is more tricky. With your existing employees, you can't simply ask them to sign off, and you also can't force them to comply with a new changed employment contract. You can't just tell your employee, this is your contract now, comply with it. You're going to be expected to be bound by this. Generally, that will not be upheld by the courts. Even ask them to sign off without further steps. generally will not be upheld by the courts. If you have them sign off, but you don't give them something extra in exchange for doing so, that generally won't be enforceable either. And so what you need to do for your existing employees is provide something called consideration. That really just means something of value that they're not already entitled to. What could that be? Any number of things: a salary increase, changes to benefits, a gift card, additional entitlements, in another way that have some sort of value to the employee. There's all number of things that this can be, and that doesn't need to be a significant amount of value necessarily. And so, for those of you who may be wondering, what am I going to give my existing employees? A lot of people I need to give something to. How can I budget for that? It doesn't need to be huge. It's not uncommon that organizations will give, a gift card to each employee who signs off of $25 or $50 or $100. Sometimes it makes sense to give more, but that is, legally sufficient when you're providing consideration for new contracts. And so you need to ensure that they get that consideration in exchange for signing. In doing that, you need to also be careful. When you're offering them that consideration, let's say you're rolling out agreements across the board for hundreds of employees. I've seen this happen a number of times before. You're offering the same, again, let's use the gift card example, the same gift card to everyone in exchange for signing off. And you tell everyone, you're expected to sign, you're asked to sign this contract by X day in 2 weeks. That day it passes, and then everyone gets their gift card. It's just an administrative step that's taken. And sometimes that step can be taken without actually confirming that they provided their signed contract before receiving the gift card. If they didn't, and you're providing that gift card, that creates risk for everyone, not only the ones who didn't sign, but also the ones who did sign and got a gift card, because they could then argue that everyone got a gift card. They didn't actually have to sign an exchange. And so that was not an exchange for agreeing to the new terms. I'm not going to spend any more time here. It continues to get a little bit more technical if I go deeper, and I don't think that's necessary for this purpose. But what you really do need to understand is that you really should be doing this with advice to ensure that you're taking the right steps when you roll out your employment agreements. Don't skip that last step. It's not uncommon for employers to get the new contracts and just think, okay, I can do this easily. This is straightforward. That last step of their rolling out the contracts is really important to get right, not only from a legal compliance perspective, but also from a best practice perspective and a strategic perspective as well. So when you're rolling out new agreements for employees, sometimes employees will be suspicious. They're wondering why you're introducing these new agreements. They may have issues with that. They may be uncomfortable. They may ask a lot of questions. They may, tell their coworkers that they shouldn't sign because, maybe there's something in there that's not good for us. You need to be mindful of that reality, especially if there is some issue with mistrust or distrust in your workplace. You can address a lot of those potential risks, those potential concerns from your employees to make the rollout much more successful with intention and with strategy. There's a number of different common strategies you might consider. One of them would be rolling out the changes in the contracts along with other changes, such as changes in your policies, like the ones I was just talking about, to reflect the new workplace realities. Another one really can be to ensure that you're rolling out new agreements and new policies consistently, every year or two, every 3 years, whatever the period is that makes sense for your workplace, rolling those out across the board in your organization just to ensure that they're updated regularly. That creates an expectation for employees at the workplace as well, that this is just our normal, every year or 2 or 3 rollout. This is normal. I'm perfectly comfortable signing off because I expect this. That's another strategy as well. But there are so many other ones, many different strategies that really will impact, your workplace specifically, considering the specific pain points that you have, your specific unique workplace circumstances. Those should all be considered, again, intentionally when you determine how you're going to roll out those new agreements, those new policies, to get buy-in, to minimize, employees pushing back and not wanting to sign, and to maximize the chances that you're going to be able to easily rely on new agreements for everyone. And so that's really the point. Take your time, get your advice, be intentional, and that's going to put you in the best position to get new agreements in place, to get new policies in place, and ensure you're protected and best situated to operate your workforce going forward. Now, the last point that I want to make before I pass it back to Laura and bring us toward the end of our presentation and the Q&A segment, I just want to ensure that you are keeping in mind you should be reviewing your agreements and policies regularly, implementing them regularly, but review them as well. Set a standard, set a period of time that you're going to do that, put it in your calendar, whatever makes sense for you. Ensure that you're planning for this so that at regular intervals, regularly you are looking at updating these agreements, updating these policies, ensuring that you understand the developments in the law. You know, keep stay on our mailing list, you know, keep an eye on our blog, keep an eye out for our newsletters. We're going to tell you about a lot of the big changes, but it's easy to miss those. People get busy. I certainly understand that. And so, you know, really being intentional and setting those times when you're going to come back and look at the policies and agreements is the best way as an employer for you to make sure that you're protected and best situated moving forward. Okay, I'm going to pass it back to Laura.
Thank you so much, Alex and Joel. That was a great review of the development and why it's important, as well as just some really practical and actionable strategies for you to consider when rolling out any updated agreements. You know, the one thing that I do want to underscore that Joel mentioned is, you know, when you are updating, getting the wording is, you know, part of it. The rollout is a big consideration, as he's mentioned, because you could have the most enforceable wording, but you miss the mark in terms of missing one of those technical requirements and not rolling out properly. And that can also invalidate the termination clause and the agreement as well. So just make sure that you are under advice. That's really important. Before we move to the Q&A, I just want to put something else on your radar. And that is that we every year conduct we call it the Proactive Workplace Law Seminar. Now, of course, because of the pandemic, it became a webinar, but we're pleased to announce that this year on May 30th, it will be in person again. And we're going to be hosting at the Richmond Hill Golf and Country Club. It is typically a sold out event. And this is, we call it proactive for a reason. And that is the content is designed to keep you ahead of things as best as we can, but also we provide really tangible, practical, and actionable strategies and considerations for you to really ensure that you're contending with the challenges and complexities of our times, particularly in this new way that we're working today, and how employee priorities and just what they're demanding of their experience and entitlements in the workplace has also shifted. So mark this on your calendars, and more to come. We will be sending out registration details shortly. And with that, let's move to our Q&A. And just to note, we anticipated we'd have numerous questions. And so I'm going to invite Joel and Alex back. We're going to try to move through as many as we can. And just to set expectations, Joel and Alex, I'm just going to go back and forth as between you. And just for those of you that may not have put your questions in as yet, note that we're providing generic responses. So this isn't intended to provide you with legal advice. I mean, if I were in your seat, I'd probably try to sneak in a few legal questions that you can act on as well. But we will not provide legal advice because naturally we'd have to have more information to provide guidance. So if you have specific questions about your agreements or anything related to terminations of employment or rollout of new agreements, feel free to ask those more detailed questions of us post-webinar, and seek our guidance and advice in that regard. But for the purposes of today, we're going to move through all of the questions that you've asked us as quickly as we can. And I'm almost going to gamify it to see if we can actually get through all 28. The other piece that I want to put on your radar, just to confirm, there were questions about whether or not the presentation and the actual recording will be provided post-webinar. And yes, we will be sending those out to you. So you'll get the deck as well as you'll get a copy of the recording. Okay, so just so you know that you can look out for that as well. So Alex, I'm going to start with you. And this is our first question. I've actually reframed it so it's not responding to what is a very specific situation, but there are principles here that I think everyone can glean from the question, which is, if an employee's employment is terminated and that employee's employment agreement refers to the Ontario Employment Standards Act, where the company's headquartered, but the employee works in another province and the termination entitlements of that province were paid out, is that problematic?
So the short answer is very likely. It could be. Technically depends on the circumstances, but yes. The longer answer is with the Ontario Employment Standards Act, It's intended to apply in situations where the employee's work isn't performed in Ontario, or it's performed in Ontario and outside of Ontario, but the outside of Ontario work is a continuation of the work that's done in Ontario. So if you have a home base in Ontario or you're going somewhere else, likely the ESA applies. But if the company happens to be in Ontario and you say have a remote worker who's in another jurisdiction, they exclusively live there, most likely the legislation that would apply would be the Employment Standards Act or Code or whatever legislation in that jurisdiction. And actually a lot of employers I'm going to take the opportunity as a side note to say, had to deal with some of these issues earlier on this year because the CRA actually released a new administrative policy as well that was effective January 1st, 2024, that required employers to reassess what the appropriate province of employment was for applicable statutory withholdings and deductions. So it is definitely, a tricky situation that could be evolving, but yes, it could be problematic, and definitely, if you are operating in different jurisdictions, that's definitely something worth assessing. Because if you said the employment termination entitlements are guaranteed, are governed by the ESA, Ontario ESA, further to the developments we discussed, well, that might not necessarily be true, might not be appropriate, and might render your termination clauses unenforceable.
All right, thanks for that, Alex. Joel, as an employee grows in their role, the job description is evaluated and updated annually. Does this mean the termination clause is unenforceable? Would this mean an employer needs to enter into a new employment contract annually? Does the latter not open other difficulties? So a multi-part question, over to you.
I think I'm the first who gets to make the classic lawyer joke. It depends. It really will depend on the circumstances. This goes back to one of the cases that Alex talked about with the substratum principle that she discussed. And so the general concept is if an employment agreement does not continually reflect the role and the duties of the employee at the time they're dismissed, that agreement may no longer be effective. It may no longer still be in effect at that time, so you can rely on the termination clause. This does depend, and you can build language into your termination clauses to help protect against that reality, and so that can make it less required to annually roll out new employment agreements, because in some cases that can be a little bit too much. It depends. So you want to make sure you have that language in there to protect against it, but without that language, absolutely, the change in duties can be an issue. Now, to the latter part of the question, does this create other difficulties? Potentially, but as I was saying a few minutes ago, if you have a general expectation among your workforce that employment agreements are going to be updated on a fairly regular basis, that really will help address some of the difficulties where employees are wondering, why do I have to sign a new contract so regularly?
Thanks, Joel. Alex, this one's yours, and I'm going to add a little to it. If a workplace payroll is under 2.5 million, and is the only enforceable ESA minimum 8 weeks notice. And what I want you to add to this, because this is a quick one, is how should gross annual payroll be assessed?
So in this case, so first of all, no, it's not the only enforceable ESA minimum. From a termination pay perspective, yes, there's no severance pay entitlement if your total payroll is 2.5 million annually, but your termination clause actually has to contemplate the possibility that you could grow to that perspective. So if you don't contemplate the possibility that severance pay could be applicable, your termination clause could be found to be unenforceable. And there are also other entitlements on termination of employment, such as the need to, for example, continue benefits. Again, you might not provide benefits to your employees, but you have to contemplate the possibility that you may, and in that event, what their termination entitlements would be. And this goes back to some of the discussion, some of these termination clauses get very, very technical. The requirements get very, very technical.
All right, thanks, Alex. Joel, if a termination clause did not stipulate temporary layoff provisions, could that be seen as unenforceable termination language? That is absence of a part of the clause considered by lawyers or the court?
This is an interesting question. So There are a couple of different parts to it. The more specific aspect of the question, if you don't provide for the right to temporarily lay off your employees in your termination clause, does that mean you can't rely on the termination clause in the event of a termination? There's no case law at this point that would say that's the case. So you don't need to have a temporary layoff clause in your contract in order to be able to rely on a termination clause when you're actually dismissing your employee, as long as it otherwise has the right language in that termination clause, like we were talking about earlier. That's not necessary. Now, if you temporarily lay off an employee and you follow the ESA's rules, but you don't have a temporary layoff clause in the contract, then that's going to be seen as a termination situation. And so then you may be looking at more of an issue. And so, for that reason, we're always recommending that employers, include temporary layoff clauses in their contracts wherever possible. Now, the more general part of the question is the absence of part of a termination clause considered by lawyers or the courts. Absolutely. It depends on what absence we're talking about. I spoke about the specific one, but you do need to ensure that, the parts of the clause that do need to be there are there. And there's lots of case law, including for about 10 years before Alex picked up in 2020, looking at some of the big developments we've seen. Lots of case law where the courts have said, you don't include this one very important bit of language that would be consistent with the Employment Standards Act's termination rules, and therefore the termination clause is not enforceable.
All right. Thanks, Joel. Alex, how does this new development, the Dufault development, impact probationary employees whose employment is terminated during the probationary period?
And so again, presuming they have written employment agreements with termination clauses, the termination clauses would be impacted in the same way as any other termination clause. So probationary periods can be really helpful, but probationary periods do not override ESA minimum entitlements. And this is particularly evident in circumstances where, as the question asks, more senior positions with longer probationary periods. We frequently see 6-month probationary periods, but if that employee is entitled, has been employed for 3 months, they're going to be entitled to at least a week's pay under the Employment Standards Act, even if they're still in their probationary period for 3 more months. So the probationary period, again, is useful because it gives you an opportunity to assess suitability. It might impact, risks and options when it comes to terminations in a particular set of circumstances, but it doesn't change the impact of this or the potential enforceability of a termination clause.
All right. I'm going to actually stick with you for this next question, Alex. Can we define which behaviors exclude reprisal?
That's a really good question because reprisal is very complicated. And interestingly, different statutes have slightly different tests for what constitutes reprisal. The nice thing with the ESA, which is what we were specifically talking about here, is that it actually gives you a little bit of a laundry list. And it tells you in section 74 of the ESA what kinds of things could be behaviors that you are prohibited as an employer from intimidating, penalizing, dismissing, or threatening an employee for asserting those rights. And that could be them asking about their ESA rights, requesting that an employer comply with the ESA, filing a complaint, becoming eligible to take a job protected leave under the ESA. And so essentially, in those circumstances, what happens is the test is, did the employee do something to assert their right under the Act? Were they penalized in some way? And is there some connection between the two? And the difficulty is that the burden of proof is on the employer to show that it didn't reprise against the employee. So, an employee could have been, penalized for something that had nothing to do with asserting their rights. They could assert the rights. There could be a penalty. They could be entirely unconnected, for example. But those would be the pieces that would have to be established and looked at to determine whether or not there was reprisal. And again, the test is similar for other statutes, but there are some important fine nuances. So this would be another one where it's really, really context specific and would definitely warrant getting legal advice.
Thanks, Alex. Joel, I'm going to give you the next two. And in the spirit of gamifying, trying to get as many questions answered as possible, I think these are pretty quick. So the first one is, how long does an employee have to file a wrongful dismissal or human rights claim?
Fairly quick, although not quite as quick as the question. So employees have 2 years to file a lawsuit in the courts. So that can include a wrongful dismissal lawsuit. It could also include a component that is a human rights claim. So if it's a human rights claim being brought before the courts with other claims, 2 years. If it's a human rights claim before the Ontario Human Rights Tribunal, then it's a 1-year limitation period to look at.
Okay, and a request for clarification. With an enforceable termination clause where it clearly states or refers to the ESA, does this mean we don't necessarily have to provide reasonable notice, meaning if we pay the minimum?
So this is one of those ones where I'm gonna echo what you said a moment ago, Laura. We can't give specific legal advice, and it's important to say here because the context of this clause is going to be really important to the enforceability here. There's a couple of important principles to keep in mind here when you're considering this, though. There's some case law that says a termination clause has to say the employee will only get what the Employment Standards Act provides in order for that to be enforceable. If it doesn't limit the employee to those ESA entitlements, then they might still be entitled to common law notice. In addition to that, if the termination clause implicitly excludes certain components of what employees are entitled to under the ESA at termination, then that can also render the termination clause unenforceable, even if the clause itself says we're going to give you what the ESA says.
Okay, and I am going to stick with you for this one because you just touched on it in your segment. So this is all about, introducing employment agreements where, employees have been there for a long time. They've only received their employment agreement originally at hire. And what would incentivize them? Why would they sign an employment agreement, a new one, that further limits their entitlements at termination?
It's a good question. And, there's any number of things that are going to incentivize employees. Of course, the consideration that I was talking about, that something of value that you're offering to them in exchange, that's the most obvious incentive. The more you offer them in exchange for signing something that doesn't impact them in that moment, they may not feel that they're going to be dismissed anyway, the more likely it is they'll be incentivized. But that's not all that there is either. Many employees will happily sign and really won't spend more than a moment thinking about it. They have a good relationship with their employer. They understand that policies are rolled out regularly, different things are rolled out regularly, and they'll sign off without really spending a lot of time. In addition to that, there are other ones who will receive that agreement and they'll review it and they'll feel comfortable with it. Keep in mind when we're talking about this termination clause language, in many cases, employers will already have termination clause language that provides on its face, if you're not the court finding those gaps in the termination clause, provides on its face for the same thing that the new termination clause provides for. It might only have a few words that are different in some cases, but even if it's a more fulsomely different clause, it still might provide for the ESA minimums. And so, on its face, that clause does look similar, and it may not require much incentive for that employee to be interested in signing off. The last incentive that I'll mention, just as employers, good employers are going to do what they can to, create trust with their employees, ensure that their employees, feel good about their relationship with the employer. Employees will do the same thing, and many employees will sign off because they want to maintain that strong relationship with their employer.
And again, last one, sticking with you, Joel, just because there's been a few questions about consideration and what would we recommend or what would be considered appropriate consideration. You've already answered this, but just to drive the point home, if you can just touch on that again.
Absolutely. So consideration doesn't have to have a certain amount of value. It just needs to be something new and have some value. And so consideration can be very little as long as it's something that has value to the employee receiving in exchange for signing. There's no minimum requirement at the law for what the consideration will be. The example I often give when I'm talking about this, you sometimes hear stories about houses being sold for $1 in certain cities where real estate is worth a little bit less than it is in the GTA. And in those cases, there's a reason why that house is being sold for $1. It's basically being given away, but the $1 ensures that contract is enforceable. It follows the same principle. It needs to be something of value. It doesn't need to be a certain minimum amount.
All right. And here's the final question. I'll give this to you, Alex, and Joel, feel free to also chime in just because we're at time. What responses, what can an employer do if an employee refuses to sign a new contract?
Well, I think that depends on what the circumstances are. So, as employers, your employees best, and there may be a variety of reasons why somebody doesn't feel comfortable signing an employment agreement. As Joel mentioned, some employees might not be particularly concerned. Some might have a concern with something that's completely unrelated to the termination clause. You may have changed a policy about parking that they don't like and that really hasn't been, top of mind to you, and it's just occurred to them, or there might have been a change to a commission structure, some sort of compensation. So the first thing to do is to inquire why. What is the concern? And then in some circumstances, the appropriate response might be to clarify. You might just be able to answer their questions and address any concerns. And if the employee remains resistant to signing the employment agreement, then there are a variety of options that an employer can consider that we don't really have too much time to get into in detail, but they essentially range from, just saying, okay, well, we're not going to do this in these circumstances, we'll let you stay on your old employment agreement, might be appropriate for business considerations in some very specific circumstances. You might modify some particular clauses that aren't that important to you, but are to the employee. Or you might take a harder line stance where you essentially say, well, here's what's happening. Your employment can't continue under these particular circumstances. And again, there's very specific technical requirements where you might have to give notice, present another offer of employment. So all of these, I would say, ask the questions, examine what the situation is, and then make sure that you get legal advice, because navigating those kinds of situations can be very, very tricky and very technical.
Yeah, and I'll say, just to add a tiny bit, I'm going to only echo what Alex said at the end there. I think those points are great. And of course, as Alex said, there are more that depend on the circumstances. This goes into the strategy that I was talking about, that Laura was talking about, in rolling out new agreements. You want to be very, very strategic. Get the advice, be intentional. Don't rush, and make sure you're looking around every corner when you're considering what those options are, because they're going to impact that employee, they're going to impact your other employees, and more.
All right, Alex and Joel, thank you so much for your insights that you shared today, and just for going through this rapid fire Q&A. I think we covered a lot of the questions, because naturally people are asking a lot of the same things. And again, to those that attended, thank you so much for taking the time. We hope you got some really good, valuable takeaways that you can apply in your organizations. And again, save the date, May 30th at the Richmond Hill Golf and Country Club. Hope to see you there. It will be time well spent. All right, everyone, have a great day. Thanks again for joining us.